Thank you so much for being with us. I'm Madison Wade. The man found guilty in 2 cold case killings from the 1980s is expected to be sentenced today. Mitchell Gaff admitted in April to murdering Judith Judy Weaver and Susan Vesey in separate cases that went unsolved for decades. Prosecutors say 42-year-old Weaver was killed inside of her Everett home in June of 1984. 21-year-old Susan Vesey was murdered inside her home while her 2 children slept nearby in 1980. According to investigators, undercover officers posed as representatives from a gum company, like chewing gum, during a fake research study in January of 2024. Police then collected pieces of gum that Gaff chewed during the meeting. They sent them to a lab for testing. A forensic scientist later determined that the DNA from the gum matched evidence recovered in Weaver's killing. Gaff was arrested and booked in May of 2024 by the Everett Police Department for the murder of Judy Weaver. Then we know he was also arrested and charged for the murder of Susan Vesey. King 5's Sebastian Robertson previously reported on this case and has more details now on this investigation.
61-year-old Mitchell Gaff is charged with first-degree murder, arson, burglary, rape, and kidnapping, alleged crimes that date back to a single alleged incident 4 decades ago. Back then, Everett Fire found 42-year-old Judith Weaver dead inside her home. Court documents reveal she'd been bound. Investigators were able to retest DNA evidence left at the scene and connect Gaff to the crime all these years later.
We had a lot of detectives. It wasn't just one, and ongoing work. I can't comment too much on it yet because there's still work to be done, but it takes a lot of tenacity and vigilance to continue working on a case as old as this one.
Last year, the Washington State Patrol Crime Lab began testing DNA evidence collected in '84. They tied Gaff to the crime by running the results through a database used to store profiles of convicted criminals. Gaff was convicted of assaulting a woman in 1979. 5 years later, he was convicted of raping 2 teenage girls in Everett. He was incarcerated on McNeil Island, a facility for violent sex offenders, and was released to a halfway house in 2006.
State of Washington v. Mitchell Allen Gaff.
Today in court, nearly 40 years after the death of Judith Weaver, he's charged in her killing.
I think it gives them some hope. I'm not sure if peace has come yet. There's still a lot to go here, right? So I think people are excited to know that cases that are as old as almost 40 years can still be charged.
And that sentencing for Gaff is expected to begin at any moment. Typically, in sentencing cases like this, there are victim witness statements that might happen. So family members of Weaver and Vesey will be there in court and can speak directly to the person who is guilty, who could be, in this case, Mitchell Gaff. So he faces the possibility of life in prison without parole. We want to go live to our courtroom now, where this is all going to take place here in just moments, to check in with our crews as we are expecting that sentencing to happen at any moment. If we can show you a live photo and video from the scene inside the courtroom now.
So it's rushing, and then I forgot my record. Of course, but I can't log into my phone. Forget about it. So whenever you don't want to be doing it when things are starting. This is part of my process. Me too. I may not feel that way on the red-eye flight tonight. What are you gonna do? Yeah. Did you know that Kimmy is from Missouri? That police officer. Last time she was here, she went to Holliston, which is a national park. Oh my gosh, I didn't know that. It's such a small world. I remember learning about it in social studies class. My laptop is not working. If I can't log in, I'm going to have to take someone else's. So I have the RCWs for what a victim. The definition of a victim. Okay. Yay. No? Hey, Caleb. I just got locked out of my laptop. So mad. For psychological, made me so mad.
It's sort of beside the point, though. We're not punishing him for what he might do. It's what he's done.
And he lied.
Yeah.
He was lying. And the guy's like, oh, I don't think he's a psychopath anymore. Oh, okay. These were 40 years I think we're ready whenever everybody else is.
Look it out. Yeah, I wouldn't mind. Thank you.
No.
First time I met him was like, oh,
Everybody will be coming through this way, but I put my laptop back next to yours just in case. Good looking out. Sorry, say again? Yes, oh, good looking out. I think I usually keep it off unless I'm doing a Zoom meeting or whatever.
I wish Dick, I tried to call Dick Howe to see if he was coming, but I couldn't get hold of him.
you what?
I tried to call Dick Howe to see if he was going to come. To try to call him later.
Oh, sorry.
Happening right now is a sentencing for this man right there with the white hair, just sat down, Mitchell Gaff. He admitted to killing 2 women in the Everett area in April of this year. Those murders happened in the 80s. Susan Vesey as well as Judy Weaver. Right now, the sentencing is happening in a Snohomish County courtroom. King 5 is there. As you can see, family members and friends of those 2 victims have packed this courtroom. They will have a chance to speak directly to Mitchell Gaff, who again admitted to those killings in April. The sentencing is happening right now. We will listen in right here.
names underneath there, everybody. Oh, I see, Josh. You want- Okay, my.
All rise. Snohomish County Superior Court is now in session. The Honorable Judge Acolico presiding.
Good afternoon, please be seated. Mr. Matheson, will you call the case, please?
I will, thank you. Good afternoon, your Judge. If we can next go on the record in the matter of State of Washington v. Mitchell Gaff, that's cause number 241-0065431. We come on today for sentencing on 2 counts of premeditated murder in the first degree. I'm Craig Matheson. I represent the state. Co-counsel Sarah Johnson is present, and lead detective Susan Logothetti is to my immediate right. The defendant, Mr. Gaff, is present. He is in custody. He is dressed out in civilian clothing, and he is not shackled. His attorneys are Heather Wolfenbarger and Mr. Lenz Adams. I am ready to make my recommendation to the court. Just let me know when you're ready. Want me to do that?
All right, thank you, Mr. Matheson. Any remarks from the defense, Ms. Wolfenberger, before I proceed?
No, Your Honor.
All right, I just want to put on the record that I have received the sentencing materials from both sides, to include the victim impact statements as well as the psychosexual risk assessment report that the defense provided. So we may proceed now.
Thank you, Judge. As I mentioned earlier, we are here for sentencing on 2 counts. Count 1 was premeditated first-degree murder for the killing of Judy Weaver that occurred between June 1st and June 2nd of 1984. And count 2 was the premeditated murder in the first degree of Susan Vesey that occurred in between July 11 and July 12 of 1980. Because the dates when those crimes were committed, we fall under the indeterminate sentencing that was in practice at that time in the state of Washington, as opposed to the Sentencing Reform Act, which only includes crimes that occurred July 1, 1984 and moving forward. For an indeterminate sentence, the court needs to set both a maximum and a minimum sentence. For first-degree murder, the maximum obviously is life, and the minimum sentence is one that the court needs to set. RCW 995-011 gives the court some guidance on how to go about reaching that minimum sentence. And 9511 states that the court should set the minimum term reasonably consistent with the purposes, standards, and sentencing ranges of the SRA. So I guess the initial question that the court needs to answer is, what is an appropriate and proportional amount of time to sentence the defendant for these uniquely vile incidents, particularly when they happened 42 and 46 years ago, respectively. So I think we actually need to look into what the defendant did in July of 1980 and June of 1984 when coming to what is an appropriate sentence for these 2 murders. The first thing I want to draw the court's attention to is just the predatory randomness of these crimes. Susan Vesey is dead because her front door was unlocked, and the defendant happened to be out that night trolling for victims, looking for either a home to burgle or a woman to rape, and he found her door open. He let himself in, and the homicide occurred. Judy Weaver made the mistake of arriving home just as the defendant drove by, and she caught his attention, and he determined to take her because something about her interested him. And once he got into her house, he murdered her. It could have been anyone. Anyone that caught his attention or left their door open or left a window open would have been or could have been a victim of Mitch Gaff. He, in fact, is the bump in the night that should make people aware that there is mortal danger at hand. Now, another thing in looking at both of these homicides is that these crimes did not occur because he had an animus towards these two victims, that he was in need of something, that he was greedy because they had something that he wanted. These homicides occurred to satiate his sexual appetite. These were sexually motivated homicides from the get-go. In the defendant's allocution, he told the court, "I was out looking for a woman to rape or a house to burgle." And in both occasions, in July of '80 and June of 1984, the defendant found a woman alone at her home, and he raped her. The specific facts of the rape, the manner in which he bound both his victims, the hog tying, the cutting of the clothing, the use of the object on the women, all of these things go to whatever deviancy is going on in Mr. Gaff's head at the time. But I think there's really no argument that this was anything but a sexually motivated homicide in both instances. The next thing I want the court to think about, or what I would suggest the court think about, is that moment in his attacks on Susan Vesey and Judy Weaver that the defendant decided to kill these women. Both of them were completely helpless at the time that he started choking them to death with a ligature. They were tied up, they were bound, they were hogtied. They could not defend themselves, they could not move, they could not harm the defendant in any way. He had already taken from them everything that he could have wanted, yet he still decided to kill them both. And I would suggest again, this goes back to the sexual deviance that the defendant has displayed time and time again, that these crimes were sexual in nature. And from going into the apartments until the moment he left, it was all about scratching that itch that he had. On top of just the facts of the case, how the defendant got in, what he did to the women once he was inside, the fact that we are 42 and 46 years after the fact, that somehow the defendant was able to evade police for that long until science finally caught up with him. But Judy Weaver and Susan Vesey were not the only victims of those homicides. The defendant inflicted generational damage on the families of those two women. You read the victim impact statements. You've read the probable cause statements indicated that police were initially looking at the significant others of both victims and how that damaged those families generationally. And it wasn't until the late 2010s that law enforcement started to look elsewhere. You've also got two children, Josh and Deborah, who were in the apartment when their mother was murdered. Neither of them, because they were 3 months and 20 months old respectively, has any real memory of their mom. So the defendant took that from them because of his sexual deviance in his need and desire to sexually assault and murder women. So, what is the appropriate sentence for something like this? How do you come about quantifying that in cases that are just this brutal? Well, the statute gives you some guidance that essentially you're supposed to treat it as best you can like it was an SRA sentence. So that's the state's recommendation, is that the court sentence this exactly as if this had occurred when the SRA was in effect. The defendant would score out as an 8 on both counts 1 and 2 for the rapes and the burglary in the first degree that occurred less than 3 months after the murder of Judy Weaver. The rapes of Angela Bai and Myra Bai that occurred in late August of '84. The standard range on a murder 1 with an offender score of 8 is 370 to 493 months. Because count 2, the first degree murder of Susan Vesey, is also a serious violent offense pursuant to the scoring rules of the SRA. Count 2 is scored as a 0, and whatever time is imposed upon that is to be served consecutively. So 240 to 320 months for count 2. What the state's asking the court to impose is 733 months. That's the high end of count 1, 493 months, plus a consecutive 20 years for the murder that occurred in count 2. The defense is essentially asking this court to give the defendant an exceptional sentence down to 20 years. In an SRA sentence, that is the only way one can get to 20 years based upon this offender score and these 2 counts that the court is sentencing the defendant on here today. The defense indicated that there are mitigating circumstances in this particular case that break in favor of Mr. Gaff. I would suggest to the court that there couldn't be anything further from mitigating fact in this particular case that weighs in the favor of Mr. Gaff. The defense also indicates that we are, by making this standard range sentence recommendation, that we are somehow usurping the power of the ISRB. Well, no. We're asking the court to set a standard range sentence based upon what crimes the defendant committed and what his offender score is. Now, if that ends up being a life sentence for Mr. Gaff based upon his age now and the amount of time that the court imposes on him, more to the good. But what we are here asking this court to do is set a minimum sentence of 733 months, a maximum sentence of life. It is both appropriate, it's proportional, it is aligned with the purposes of the SRA, and quite frankly, the defendant earned every day of that 61 years. And I'd ask the court to give it to him. I reviewed the report from Dr. Lumens. It's quite frankly more interesting than it is relevant to what we have here today. Mr. Gaff is not seeking a SOSA. He is not here because we have petitioned to have him held as a sexually violent offender, where we're looking at risk. He is here to be sentenced for something that he has done. We are not asking this court to punish him for something he might do. We are asking the court to punish him for something that he has done. In regards to Dr. Lumen's report, I would also ask the court to take into account that when Mr. Gaff was speaking to him at least initially, he was still lying. He told the story about breaking into Judy Weaver's house, tying her up and then leaving before she was killed and the house set on fire. That's the same story he told his husband. And quite frankly, probably the story that he would have told at a jury trial if count 2 hadn't rolled around in the VC matter. So I'm asking the court to give Mr. Lumen's evaluation, such as it is, little if no real thought, because it really has nothing to do with what we're here for to do today. The last paragraph in Lumen's evaluation, however, I would suggest to you just how out of touch he is with what we are doing here today. When he talks about the murders that perhaps we ought not care as much because of the historical nature of these offenses. But realizing that there in fact may be some criminal justice issues related to those crimes. I couldn't disagree any more with Mr. Lumens than in regards to those comments. That because these murders happened 42 and 46 years ago, that the defendant was able to evade law enforcement for that long, it took that long for the science to catch up with him, that he ought to be given some sort of break, some sort of pass because of that. I would ask the court, again, to follow the state's recommendation of 733 months as a minimum, life as a maximum, set a no-contact order between the defendant and a number of named listed people in our no-contact order appendix, impose the necessary financials, and give him credit for time served. I'm more than willing to answer any questions that the court has, but that's the end of my comments.
Very briefly, with regards to the no contact orders, these are in relation to relatives.
Yes.
All right, nothing further at this point. Who's going to be addressing sentencing on behalf of the defense?
That will be me, Your Honor.
Proceed, counsel.
Thank you. Your Honor did say that you've already received and reviewed our materials, so I don't intend to belabor what has already been presented to Your Honor in our memo. I will just say that I do agree that this case presents very unique and challenging circumstances for Your Honor, in the sense that we do have horrific facts of this case that we are not here to dispute. Nor are we here to dispute where Mr. Price has been in his life. We are simply asking Your Honor, as you consider the facts of the case, the victim impact evidence that you will receive, that you also consider the mitigating circumstances that Mr. Price does indeed have. And that is the reason why we presented Dr. Lohman's risk report. And that is why it is relevant to this proceeding. It's a mischaracterization to say that we're asking Your Honor to simply give Mr. Price some kind of a break or a pass simply because these crimes occurred decades ago. That's really not what the argument was or is. The argument centers more on the fact that Mr. Price has worked significantly in many, many years of treatment to address exactly the elements underlying his criminal offenses, including the two that he comes before Your Honor today to be sentenced on. And that's part of what makes it so unique, is we have these crimes, and yet we now have this person who is nearly 70 years old, and there is a statistically documented reduced risk of recidivism for people as they get older. That was also addressed in Dr. Lohman's report. Beyond that, Mr. Price has also done lots and lots of SOTP. Dr. Lohman reviewed his reports from 1995 to 2018, but that's actually not the only SOTP that he was engaged in. Prior to being civilly committed, he did also engage in SOTP when he was incarcerated at Twin Rivers. So he's actually got more than 25 years of SOTP under his belt. And I would note that Dr. Lohman is very well aware of each of these crimes, and it did not change his risk assessment based on the reduced risk of recidivism that is statistically documented based not just on Mr. Price's current age, but also on all that treatment that he did. So that does present a unique challenge in the sense of what is appropriate for somebody that is unlikely to ever offend in this way again, and how does that protect the public? And that is another reason why this report is relevant, because one of the goals of the SRA is protection of the community, of the public. And we submit that he is no longer that risk, or he's a very low risk to the public based on all the treatment that he has done over the years. He is simply not the same person that he was then. When Dr. Lohman initially evaluated Mr. Price, the offense involving Ms. Vesey was not known to him. And when I realized that, it occurred to me that we should have him update his report for purposes of the sentencing and make sure that that did not have any bearing on the risk assessment, or if it did, that he would revisit it, and that way we could have the most accurate and up-to-date report for your honor. And Dr. Lohman told me that based on how long ago the offenses occurred, and this is coming from a clinician and forensic expert who has spent more than 40 years working in this field and conducting these types of actuarial risk assessments for people who have committed the types of offenses that Mr. Price has done. And what he told me is based on that, and based on the factors and how they assess risk in that realm, one of the things they look at is how long has it been since the offense, and since all of these offenses occurred between 1979 and 1984, talking about all of his prior offenses, not just the two he's being sentenced for today, that those are considered index offenses. And that is why they didn't change the risk assessment. The final page of Dr. Lohman's report does say that he has worked on, Mr. Price has worked on in treatment, the issues underlying his criminality, including the murders. And that suggests that the treatment modalities in all the years of treatment that he did and his diagnoses may not have been substantially different, even if the murders had been disclosed or otherwise were known at the time that he was engaged in this treatment during his years of civil commitment. And Mr. Matheson himself has pointed out that these crimes that he's here to be sentenced for today were sexually motivated, and they were. That they were sexual in nature, as all of Mr. Price's prior offenses have been. And that is exactly the issue that he worked on for a quarter century in very intense, in-depth SOTP. Using hard drugs and alcohol also fueled his sexual deviancy, and he hasn't touched any of that since his arrest in the By Sisters case in September of 1984. We submit that these are mitigating circumstances that do warrant what we're asking for, which is just to impose the statutory mandatory minimum of 20 years. It's still going to be a life sentence, regardless, because that's what the maximum is. So as we argued in our sentencing memo, if you impose the statutory mandatory minimum, it will still meet all those goals of the SRA, but it's also a more just outcome that takes into account the mitigating circumstances that we've put before your honor. And I would say that while it is natural to beg the question of if everything wasn't disclosed while he was in treatment, has he been truly changed or rehabilitated? We don't have to rely just on Mr. Price's self-reports. And nobody, while he was civilly committed, was basing it just on his self-reports. When someone is civilly committed, they have a number of professionals that have eyes on them. People from DOC, when they're in the community, people from DSHS. Once they're released to the community, they have to have a chaperone going with them literally everywhere when they leave their home. the most stringent community custody conditions somebody can have, including registration, limits on internet access, limits even on employment when they first come out, and continuing their in-depth treatment to get at the issues underlying their criminality. They do not just hand any civilly committed person a community placement. It has to be earned through a lot of hard work, and a lot of professionals have to sign off on it. You have attorneys for the state, you have attorneys for defense, forensic experts like Dr. Lohman conducting risk assessments on each side of the aisle, both government and for Mr. Price. It's a number of people, and as Dr. Lohman also noted in his conclusion on the final page of his report, that having reviewed all those voluminous records, all those risk assessments, trial testimony, DOC records, DSHS records, SOTP records, that having looked at that, it corroborates Mr. Price's self-report, and it shows behavioral and attitude changes. They certainly don't just hand to a civilly committed person either a less restrictive alternative, and they definitely don't hand them an unconditional discharge when they no longer meet the definition of a sexually violent predator within the meaning of the law. But through his commitment to SOTP all those years, Mr. Price earned that. He is simply not the same person sitting here before you today that he was at the time he was committing these terrible offenses. And we just ask Your Honor to take all of that into consideration. Given what his circumstances are, his age, and the likely length of his incarceration, we are asking Your Honor also to find him indigent and to waive any fees. If I could just have a moment, Your Honor.
You may.
Your Honor, I think that does conclude my remarks at this time.
And Your Honor, before the court pronounces sentence.
No, sorry, Ms. Johnson, sorry to interject. Before I hear on that point, I just had a question for Ms. Wolfenberger.
Of course, Your
I wanted
Honor.
to clarify something for me. Ms. Wolfenberger, I believe in your earlier comments, you indicated a conversation you had with Dr. Lohman.
Correct.
Now, as I take it, he authored just one report.
So, Your Honor, he had authored a previous report that the state is in receipt of. That initial report was dated October 2025. The report before you, I believe still has that same date on it, but was updated as of early May of this year. The updated report does indicate a second interview with Mr. Price that happened, I believe, on May 6th. But beyond adding in the facts of the BC case, it is the same report. There's no difference as it relates to the sections on his criminal history. The facts of the Weaver case were all in there. All the facts about the actuarial risk assessments, his diagnoses, and how those have changed over the years, how the sexual sadism disorder diagnosis and substance use disorder diagnosis no longer applies to him based on his age and based on all the treatment that he has done. All of that was part and parcel of the initial report. The only change to it is just to add in the facts of the BC case. And it did not change any of the risk assessment, if that was what Your Honor's concern was.
Yes, all right, proceed. Thank you. Ms. Johnson.
Thank you, Your Honor. I just wanted to catch the court before moving to the pronouncement of sentence, if that is what we're going to be doing next, because there are a number of family members from the victims' families who are present, some of whom would like to make statements. Before I turn it over to the victim impact portion of today's hearing, I do want to acknowledge the fact that Joshua Vesey and Deborah Newton, Susan Vesey's children, are present on Zoom today, as well as Greg Glasser and Paul Glasser. They're Susan's brothers. I also wanted to let the court know that Kathy Myers and Colleen Kaiser, who are Judy Weaver's daughters, are present in the courtroom today, as well as Leon Gregory, who is Judy's brother. Your Honor, turning to the counts in turn, starting with count 1, the homicide of Judy Weaver. Leon Gregory, her brother, would like to make a statement to the court.
And Your Honor, if I may, before we jump into that,
Just a second, before I get to hearing from the other individuals, I was still gonna stay, and thank you for addressing that, Ms. Johnson. I was still gonna ask another question, which was,
Oh, yes,
is
Your
the
Honor.
defendant, at the sentencing, the defendant has the right to address the court. And he doesn't have to, but if he chooses to, there'll be a time when he does it. And I wanted to follow up with you to determine if your client was intending to address the court at his sentencing.
and yes, Your Honor, when it is his time, he will be addressing the court. I will also add that because there was a mention about him sort of reporting different things about the offenses, particularly as it relates to Ms. Weaver, that he stands by his admissions, that his very clear and detailed admissions that were made at the plea hearing in April. And his statement today still stands by those admissions. And that is what his position is on these cases and what his actions were.
All right, thank you.
And then, Your Honor, what I wanted to, I'm sorry, before we get into everything, I thought it might be prudent to let the court know that we do have an objection to a couple of the speakers that intend to speak today. I thought it might be prudent to raise that issue to you before we begin, just so that once we do begin with the right of the victim survivors to speak, that we don't interrupt that flow. And if I may, I was informed prior to the sentencing that Ms. Jacqueline Brown is present and would like to address the court, as well as her sister, who happens to have been a neighbor and close friend of Ms. Weaver's. And if I may, Your Honor, as to Ms. Brown's sister, if it's true that she was a neighbor and a close friend, I think that probably does fall under the definition of a victim survivor within the meaning of the victim rights law, both constitutional and statutory. So we wouldn't object to her speaking, but to Ms. Brown, she certainly is a victim of Mr. Price's for a 1979 crime. I do not know of any connection that Ms. Brown has to the victims of these crimes that Mr. Price is being sentenced for today, either Ms. Vesey or Ms. Weaver. That being the case, we do object because we do not believe that she falls under the definition of a victim survivor for purposes of today's sentencing and for what we're here for today. We would also add that Ms. Brown certainly has had opportunities to address the court about the crime that Mr. Price committed against her through her trial testimony in 1980, at the sentencing hearing that occurred in that matter. We understand that she also testified in at least one of his proceedings, one of the trials pursuant to 7109, one of the civil commitment trials. As to Ms. Brown's sister, again, we agree that she may be a victim survivor within the meaning of the law. However, we would ask that any evidence or testimony given by her today focus on her relationship to Ms. Weaver, as that is one of the crimes we're here to address today, and the impact of Mr. Price's crime against Ms. Weaver, rather than the 1979 crime committed against Ms. Brown, as that is not the case here today that Mr. Price is here to be sentenced for. And victim impact evidence has already been presented on that case in sentencing that occurred in that case years ago.
All right, thank you. When did you become aware that Ms. Brown was going to be addressed in the court?
Your Honor, as we entered the courtroom this afternoon for sentencing.
All right, what's the state's response?
Your Honor, we did inform defense that we would, as we received notice of who would like to speak today, be providing that notice to defense, but that in emotionally difficult and charged hearings such as this, sometimes people make decisions at the last moment. Today I learned that Ms. O'Brien would like to address the court, as well as her sister, Elena Brown. Additionally, after I had an opportunity to speak with Ms. Wolfenbarger, I was informed by victim advocate Kimmy Nolte that Paula Keeler, who was Susan Vesey's best friend, would also like to address the court. That wasn't included in Ms. Wolfenbarger's objection. I'm not sure if she would concede that a best friend of a victim is a victim survivor, but I'll let Ms. Wolfenbarger address that separately. There's no real question that Jackie O'Brien is a victim of the defendant. I would ask the court to look at RCW 769030, specifically subsection 1. This chapter of the RCW provides rights to victims, survivors of victims, and witnesses who are going to presumably be called at trial. There is a right of victims and victim survivors to present victim impact statements to courts during sentencing proceedings. Whether or not Ms. O'Brien is a victim of this particular cause number is up to interpretation. I think it's clearly and squarely within the court's discretion whether or not she has a right to speak today. But I would ask the court to allow her to give comments. And the reason being that she is a witness in this case. She has had to relive the trauma that the defendant inflicted upon her in 1979 in preparation for this trial. Her story is an integral part of the defendant's modus operandi for the murders of Susan Vesey and Judy Weaver, and the defendant has had a lasting impact on her. I will let the court know that when she spoke at her own sentencing, the court didn't take her very seriously and let the defendant out on a deferred sentence. And just shortly before that, he had murdered Susan Vesey. So I am asking the court, in your discretion, to allow Ms. O'Brien to make a statement today.
Ms. Johnson, when you refer to Ms. O'Brien, are you referring to Ms. Brown?
Yes, Ms. O'Brien is her name now. At the time of the offense, she was Jackie Brown.
And that's my fault, Your Honor, in referring to her by her prior name.
All right, thank you. That's why I was trying to clarify. I knew you were not objecting. I didn't hear you objecting, Ms. O'Brien. And with regards to Ms. O'Brien's sister, my understanding then is that you're not objecting to that. Is that correct?
Correct. As to the relationship, I think, that if they were close, then in my mind, that seems to fall under the statute. But yes, again, we would just ask that any commentary be focused on Ms. Weaver and the crime against her. I think that Ms. Johnson may have mentioned that a close friend of Ms. Vesey's is asking to address the court today. We do have a written victim impact statement from somebody who identified herself as the best friend. If that is the same person, again, based on what was written in the victim impact statement, it was pretty clear to me that she would also have a right to speak. It was a very, very close relationship, almost like a sister. So we didn't have any objection to that. Are we talking about the same person, Ms. Keeler?
Yes, it's the same person, Your Honor.
Yes, so we don't have an objection there. Like I said, upon reading her statement, it was very clear to me that is somebody that would be contemplated by as a victim survivor under the law.
All right, thank you. And Ms. Johnson, Ms. O'Brien was listed as a witness in this case, expected to testify if it had gone to trial?
Depending on the court's ruling in regards to 404B, yes, she was a 404B witness in this case.
All right, at this point in time, it is still within the court's discretion, consistent with the rights of victims and witnesses to participate in this sentence, and the court will allow her to speak. It will be brief, but the court will allow Ms. O'Brien to address the court today. The objection is noted for the record. It's over.
Thank you, Your Honor. And with that, I would turn to Mr. Leon Gregory, Judy's brother, to give his victim impact statement.
Your Honor, my name is Leon Gregory. Judy Weaver is my sister. The death of Judy by the confessed killer, Mitch Gaff, has affected me and my wife for 42 years. My wife is not here today, but she is home with friends watching her because she's ill under oxygen. My parents, brother, 2 other sisters passed on years ago, never knowing who killed Judy. Whoever they are, all here today in spirit. I feel they're sitting in the first row. When my sister was a young girl, she was molested. I saw the man who attacked her. I was really hurt, and I was not able to protect her. We were only 3.5 years apart. She was a very young girl then. A special bond developed between Judy and me. I protected her and taught her how to fight back, such as kicking and you know where, punching, scratching, screaming, which I think she did on her day of her death, plus the use of the telephone. There were 2 calls she made I shall never forget, Your Honor. She wanted me to drive her to the hospital for the delivery of her daughter, Colleen. We just made it in time, and I'll never forget that day, the rest of my life. The last call was on the date of her death, Friday, June 1st, 1984. Judy called me to meet her after work. When I arrived, she was very, very busy. So we waved to each other with signals, and I said I would be seeing her on Saturday, and we agreed. That late Friday night, I received a call at home that Judy had been killed. I was hurt again and broke down, not knowing what she had wanted to talk about. Your Honor, as we all know, it's been a long 42 years since my living sister's death. The killer's DNA was the means that solved this case, believe it or not. I therefore suggest your sentencing be the maximum number of years. I thank the court for allowing me to speak. Thank you.
And thank you, Mr. Gregory, for coming to address the court today.
Your Honor, the next person to speak is Kathy Myers. She's Judy's daughter.
This is Kimmy Nolte, victim advocate with the Snohomish County Prosecutor's Office, reading on behalf of Kathy Myers. Honorable Judge, my name is Kathy Myers. I am Judy Weaver's youngest daughter. I was 20 years old when Mr. Gaff killed my mother. My life was never the same. My mother was a vibrant, funny, pretty woman. She owned a restaurant here in Everett. She also worked 40 hours a week there. I worked with her 5 days a week for 5 years. She was proud of her accomplishments, and she was good at it. I tried returning to work after her death, but without her there, the whole place just caused me sadness. I quit my job and never returned to that restaurant. Our family has always been very close. I have many great childhood memories of my grandmother, like fishing, camping, vacations, holidays, and weekend sleepovers. I have 2 children of my own. They are 40 and 37 today. They have no memories of their grandmother. Mr. Gaff killed her before they even got a chance to meet her. He robbed them of their childhood memories. There were many times as I raised my kids that I needed my mother. I cried a lot because she wasn't there. But he didn't just take her from me. She had parents, siblings, and friends who loved her. I watched my grandparents over the years cry every time they spoke about her. They both died never knowing who killed their daughter. 3 of her siblings have also passed, never knowing. Meanwhile, Mr. Gaff carried on with his life, never caring about the tragedy and hurt he caused an entire family. In fact, during the last 2 years of hearings, Mr. Gaff asked if he needed to attend all the hearings. I was very offended by this request. My sister, my cousin, and myself have attended all hearings. The 2 of them had to take off work each time. I live 3 hours away, but all 3 of us managed to be there. But Mr. Gaff couldn't be bothered to get dressed and walk across the street. He doesn't care. My wish is that he never gets to just carry on with his life
ever again. Please consider not just the severity of his crimes, but the tragedy and hardship he caused my family and Susan Vesey's family while considering their sentence. Respectfully submitted, Kathy Myers.
All right, and I also will extend my thanks on the record to Ms. Myers for addressing the court today.
Next, Your Honor, is Ernest Bennett. He's Judy's nephew.
Your Honorable Judge, my name is Ernest Bennett, and I'm here today on behalf of my mom, Sherry Bennett, who passed away in 2016. Sherry is the younger sister of Judy Weaver. I stand here not only for myself, but for my mother, who I know is looking down from heaven in this courtroom today, along with many other family members who are no longer with us because of the years that have passed since Judy's murder. Todd, Ralph, Carol, Teresa, and our grandparents, Edith and Lauren. Growing up, my mom and I often visited Judy after relocated from Ephrata to Burlington in 1980. Those visits, especially they were in Everett, were some of the happiest times my mom ever had with her older sister. The sister that she looked up to her entire life. One of my clearest memories is being at the Bell's Nest Bar and Cafe, which Judy owned. It was Memorial Day weekend, just 1 week before our entire family lives changed forever. My mom was helping Judy with the financial books, which she often did down in the basement of the bar. I was 11 years old at the time, and I was looking for something to do. I was bored. Judy comes down the stairs. I started asking her about these expired pull tabs, big boxes pulled down the basement. All of them had expired on them. And I asked her, what are they for? I asked Judy, what are they for? And she goes, they're expired pull tabs, they're no good, can't win any money on them, I just have to throw them away. So I asked her, while my mom was doing the books, can I pull them off? No harm, no foul, I'm not gonna win any money. Just for something for fun to do. Judy allowed me to take one big box, finish that box off. A little bit later, we were leaving. I asked if I could take a box home with me. So Judy allowed me to take the box home, knowing that those were expired and I was not going to win any money, but it was fun. And I told Judy, right before we left, that I'd be back in 2 weeks. Because in 2 weeks was Grandma's birthday and my mom's birthday. They were 1 day apart, June 12th and June 13th. So we were going to come back down in 2 weeks, and I'm going to collect the money. She goes, but they're not worth anything. But I am going to collect money from you. Well, unfortunately, that did not happen. I was on cloud nine for that whole time. That moment, that simple kindness, this is the memory I have of seeing my aunt alive for the last time. Judy was an incredible mother, wife, aunt, sister, daughter, and friend. She was the kind of person that would help a stranger just as quickly as she would help a family member. She didn't deserve what happened to her. I'll never forget the morning our lives changed. I woke up to the sound of my mom screaming, no, it's not Judy. It can't be. I walked down the hall to see my dad, or to see my mom on the floor, on her knees, hands over her head, screaming, yelling, crying, sobbing uncontrollably while my dad was on the phone receiving the news that Judy had been murdered. That moment is burned. It's my memory. It has never left me. For 42 years, not a single day has passed without Judy being thought of and missed. She was an innocent woman walking home after work, minding her own business. Her life was taken violently, senselessly. These 42 years have taken a tremendous toll on her daughters, Colleen and Gabby, on her siblings, Leon, and the rest of our family. One of her siblings, as I said, Leon's here, still alive, here today to witness this moment. A moment we have waited for nearly half a century. It breaks my heart that our grandparents are not here to see this. Our grandmother had one wish before she passed, was to see the person who murdered her daughter caught and be held accountable. Today, we stand here carrying that wish for her. Your Honor, our family is asking for justice, not only for Judy Weaver, but for the others whose lives Mitchell has took far too early and under horrific circumstances. We believe we should receive the longest sentence possible. We know that no sentence will bring Judy back. But after 42 years, accountability matters. Justice matters. And seeing this case finally reach this courtroom shows us that even after decades, the truth can still come to light, and those responsible can still be held to the fullest extent of the law. Thank you, sir.
Thank you, Mr. Bennett, for addressing the court today.
Your Honor, I believe next, Kimmy Nolte will read a statement from Joshua VC, who's present on Zoom today.
This is Kimmy Nolte again reading on behalf of Joshua VC. Your Honor, my name is Joshua Mark VC. I was born on April 6, 1980. My mother, Susan VC, was 21 years old when she was murdered on July 12, 1980, just one day after her birthday. I was 3 months old. My sister was not even 2. We were both in the apartment. I was in the same room when the defendant killed my mother. My sister was in her crib in the next room. Susan VC was found bound on the floor. I was found swaddled on her bed. This is the beginning of my life. The defendant did that. My father, Ken VC, and my grandmother, Judy Glazier, found her body that morning. They found her in the same apartment complex where her 5 younger brothers lived, just around the corner. I never got to know my mother. Everything I know about Susan VC comes from stories. Stories of a loving, God-fearing, 21-year-old woman who cared deeply for her family. She was just starting her life as a mother when the defendant took it from her. What the defendant took from me and my sister was not just a life, it was a mother's unconditional love. The kind of love that shapes who you become before you can even understand it. That is something we will never have. We were children, we were in that home, and the defendant killed our mother anyway. Growing up without her affected everything. My family did what they could. My grandmother, Judy, and my aunts stepped in and raised us as best they could. My uncle stayed involved in our lives and supported us when we needed it. But none of them were our mother. When I was 10 years old, I learned the truth that he murdered her. That changed me in ways I still carry today. For years, there were no answers. Suspicion tore through my family. People questioned each other. It divided families that were already broken by what the defendant did. And I grew up in the middle of that emotional scarring. Even as an adult, even as a father, I have to live with the consequences of the defendant's actions. I've had to make decisions in my own life based on fear and uncertainty that should have never existed. The defendant did that. Susan VC was 21 years old. She was in her own home. Her door was unlocked, and he chose her. He targeted her. He didn't accidentally end her life. He entered a home, he made a decision, and he took a mother from her children while they were in the apartment. and then he lived 46 years without telling the truth. At any point, he could have stopped the confusion, the suspicion, and the pain that spread through my family. He didn't. Even now, he's minimized what he did. He called it, quote, actions leading to her death, unquote. That is not what this was. He hunted women, he planned it, and he executed it. My mother was not an accident of circumstance. She was a victim of his choices. There is no sentence that can give my mother back. There is no punishment that can undo what he did to me, my sister, and my family. But there is accountability. I am asking this court to impose the maximum sentence allowed under the law, life in prison. Because what he did to a 21-year-old mother while her children were in the home deserves nothing less. Thank you.
All right, again, thank you to Ms. Bessie for addressing the court.
Your Honor, it's my understanding that Deborah Newton, who is also Susan Vesey's daughter, would like to address the court next. And my apologies, Your Honor, Ms. Nolte will read a statement on her behalf.
All right, and the last speaker that addressed the court, that was Ken Bessie through Ms. Nolte, correct?
That was Joshua Vesey.
Joshua Bessie, sorry. Yes, so thank you, Mr. Bessie. You may proceed, Ms. Nolte.
This is Kimmy Nolte reading on behalf of Deborah Newton. My name is Deborah Newton, and I am Susan Vesey's daughter. My mother was brutally raped and murdered on July 12, 1980. For over 45 years, my family has grappled with not knowing who had taken her from us. The loss of my mom has affected so many people close to her and changed the trajectory of generations of her family. I had to grow up without a mother, and my kids never got to know their grandmother. I had to learn how to be a mom to my kids without ever having had one myself. I can't tell you how many times I wish I had her here for advice, to help me through the trials of life, or even just to share in my joys. Every single big event in my life, my kid's birth, meeting my spouse, my kids getting married, and my kids having kids of their own, all of these were highlights of my life that I desperately wished I could have shared with her. My dad struggled with drug addiction and grief from the time she died until he passed away last year. He was just not the kind of parent that would or could step in to fill her shoes and be who I needed him to be. To say I had a tumultuous childhood because of this would be an understatement. As I was writing this letter, I was trying to express just what a huge impact this loss has had on me, and there are frankly no words to truly convey how painful it's been. Mitchell Gaff made comments in his statement of guilt to the court that, quote, because of his actions, she died, unquote. This makes it sound like he inadvertently caused her death, and this is almost what you would use to describe a death by manslaughter or accident. I think words matter, and I wanted him to have said, quote, I killed her, unquote, or, quote, I murdered her, unquote. Because that is what happened. He had the intention to hurt someone that morning, and he hunted her down, then savagely raped and murdered her with me and my brother in the apartment. He showed no remorse or consideration for what he was doing to another human being, let alone a young mother with children present. And he didn't stop his reign of destruction after her murder either, because just 4 years later, he robbed Judy Weaver's family of their loved one. I have to admit that all these years as I waited for justice, I had hoped that the terrible things that happened to my mother that morning had occurred after she died. And I was completely devastated to learn that, based on his account of events, that was not the case. Gav has enjoyed over 4 decades of freedom from retribution for the crimes he has committed. He has been allowed to live out the prime years of his life, while those he victimized were not given that chance. He did not admit to these crimes because of a bout of conscience. He did so because he was caught. In both Judy Weaver's and my mom's cases, justice has frankly come too late. Too late for my dad to get a resolution to who killed his wife before he died. Too late for my grandparents to know who murdered their precious only daughter. And too late for her oldest brother to know what happened to his beloved sister before he passed away. But late justice is better than no justice at all, and you can still give some semblance of justice to me, my brother, her brothers, and her other family and friends who loved her. I implore you to give him the maximum sentence allowed by the court, life without the possibility of parole. He has already enjoyed more years of freedom than he deserved, and he shouldn't even get the possibility to spend one more day a free man. Thank you for allowing those that loved or never got the chance to love Susan the chance to speak to the court. Thank you.
All right, thank you, Ms. Newton, for addressing the court today.
Your Honor, I think that Ms. Keeler has given Ms. Nolte a photo of Susan BC that Kimmy is displaying for the court. Two photos, Your Honor. We can get copies of those for the record.
I'll ask that copies of those photographs should be supplemented into the record as part of what was presented in court.
Dear Honorable Judge, my name is Paula Keeler, and I'm here to speak about my best friend, Susan Rainiel Glasser BC, whose life was taken 46 years ago in an act of unimaginable and horrific violence. I grew up with Susan from elementary school through high school and into our young marriages and early years as mothers. Her family was my second family. We spent countless hours together over the years. She was not only my best friend, but truly my soul sister. Susan and her husband, Ken Vesey, introduced me to my first husband, the father of my 2 children. Susan and I navigated life side by side. We spoke often. And the last time I heard her voice was on her 21st birthday. She shared how much she loved her children and what wonderful babies they were. She was so happy to be a mother. We caught up on family news and ended our call the way we always did, with, "I love you." The next day I received a call from Judy and Bill Glasser, her parents, telling me that Susan had been murdered. It was impossible to process. My immediate thoughts were about her children. Were they safe? How could something like this happen to someone so loving, so full of life? There were no answers. The grief that followed was overwhelming. The realization that I would never see her again, hear her voice, or share life with her sent me into depression. The murder of Susan did not just affect one moment in time, it changed the course of our lives forever, and I still feel the pain of her absence. I grieve for her children, who were left to grow up without their mother, for her husband, who lost his wife, for her parents, her brothers. There are no words that can fully capture what Sue endured in her final moments. She was attacked in a place where she should have been the safest, in her own home, and subjected to extreme violence by a man who took pleasure in the act of taking her life. Her 2 young children were present. Her children were present. While they survived physically, their lives and all of our lives were permanently changed. For 46 years, we lived without answers. That uncertainty created an ongoing fear that affected how I lived my life and those in the families involved. I was warned to be cautious, to protect myself, to always be aware. That fear stayed with me for years and still impacts me today. I continue to lock doors, windows, wherever I go, because the reality of what happened to Sue has never left me. But Susan is not defined by the violence done to her. She was warm, she was loving, she was intelligent and full of life. She was a woman of deep Christian faith who shared the love of God with everyone she met. She wanted others to know the love of a Savior who died for our sins. She lived her faith in a genuine and meaningful way. I remember Sue standing at her wedding, singing the Lord's Prayer to her husband, her voice filled with love, hope, and faith. I remember when my son was born and she came to help me. We were young mothers excited to raise our children together and share that journey. And that future was taken from us. For decades, we have lived with her absence, missed birthdays, holidays, milestones. Her parents, brother, and grandparents went to their graves without knowing who took her life. The lack of answers caused lasting pain for everyone who loved her. I believe Susan is now in her eternal home, reunited with her family. It brings a bit of peace, but it does not erase what was done or the suffering she endured. As someone who loved her deeply, I cannot help but think about her final moments, her fear, her pain, and her humanity. I hold on to the belief that even in her suffering, she cried out to God for help and mercy. The man responsible for this crime did not just take a life, he shattered a family. He robbed 2 children of their mother. He caused decades of grief that will never, ever fully heal. This was not a momentary act. It was a series of deliberate and conscious choices. He entered her home, overpowered her, and continued his actions despite the presence of her children. The sustained nature of this crime reflects a complete disregard for human life and dignity. For 46 years, we have carried the weight of those actions. While he lived his life, we lived with loss, unanswered questions, and the knowledge of what Susan endured. So, Your Honor, after 46 years, we're finally here. While nothing can undo what was done, justice, no matter how delayed, still matters. I respectfully ask the court to consider not only the severity and sustained nature of this crime, but also the decades of pain that followed. The sentence should reflect the value of Susan's life, of Judy Weaver's life, and the profound and lasting impact of those losses. I ask the court ensure that Mitchell Gath is never in a position to harm another person again. I carry Susan Raynell Glasser VC with me every day. Today I speak for her, for the life she would have had, for the faith she lived, and for the love she gave so freely. I place my trust in the saving grace of our Lord Jesus Christ and in the justice, even after many years, is finally being brought into the light. Respectfully submitted. Paul Keeler.
And thank you, Ms. Keeler, for addressing the court today. On behalf of your friend.
If I could just have one moment, Your Honor.
Sure, go ahead.
Your Honor, consistent with the court's previous ruling during this hearing, Lena Brown will provide her victim impact statement next in relation to her relationship with Judy Weaver. She's going to have Mike O'Brien, who's Jackie's husband, give the statement on her behalf.
Good morning, Your Honor, or good afternoon. I'm speaking for Jackie's sister, Lena. And Lena knew Judy Weaver. She and her husband, Elmer, lived across the street from me on Hoyt. When they divorced, Elmer sold the house to me. Judy moved back into the brick apartment on Rucker Avenue just behind her own home. When Judy was killed, many people suspected that either Elmer or the guy that she was dating had killed her. As it turns out, it was Mitchell Gaff. Elmer died never knowing the truth, and Mitchell Gaff has destroyed many lives, and the whole situation has been accumulative over many, many, many years. So please hold him accountable, Your Honor.
All right, thank you. And that was a letter from Lena Brown.
That's correct, Your
All
Honor.
right, thank you for addressing the court.
The last victim impact statement today, Your Honor, will be Jackie O'Brien.
Thank you, Your Honor, for the opportunity to speak to you. I've written these words for days. I've got long versions, short versions. My husband says stick to the short version, but I'm going long. I ask you to bear with me if I struggle or break down as I read the words that I want to share with you. It's been difficult listening to the friends and family members. My goal in reliving the horror that Mitchell Gaff brought to me at my home is that it will show how his actions have adversely impacted my life for the past 46 and a half years. Most of what I feel is guilt for what happened to Angela and Myra, Judy, Susan, and all of his other victims and their loved ones, including my husband, my sister, my mom, and my dad. I wish I had been able to kill him. My name is Jacqueline O'Brien. I'm the first known victim of Mitchell Gaff. I believe there were others before me. I believe he didn't plan to attack me, but rather I was a victim of opportunity for him. Putting the pieces together after my attack, I believe he had attacked another North Everett female somewhere near my house shortly before he attacked me. Possibly an attack that was never reported. My background is law enforcement since age 22. I've worked for the Bothell Police Department as a commissioned officer, and I retired from the Washington State Patrol when I was 45 years old. My background is law enforcement. There's right, there's wrong, there's no middle ground. Mitchell Gaff attacked me on the day before Thanksgiving, on November 21st, 1979. I was 29 years old. I lived alone in my house on Rucker Avenue in North Everett. It was a beautiful fall day, so I decided to mow my lawn. I mowed the front lawn that went into the backyard through the 6-foot-high board fence that separated the front yard from the backyard. As usual, I put a padlock on the gate so that no one could enter from my front yard. Living alone and being in law enforcement, I was always cautious. I took the grass catcher off my mower to empty it in the alley across from my garage door, which opened into the alleyway. We neighbors had created a compost area for grass clippings, in a dilapidated old shed across from my garage. The shed had no doors. It was a 3-sided old wooden structure with no roof. When I got to the shed, I saw a guy standing in the northeast corner with his back to the alley. He was naked from the waist down and appeared to be pulling up a pair of pants. I was shocked and I yelled, "What are you doing?" I thought he was relieving himself, but the fact that he was putting on pants confused me. Again, I said, "What are you doing?" He turned and said, "Oh, I'm sorry, I'm changing my clothes to go to my judo lesson." I said, "You decided to change your clothes and get naked in a neighborhood alleyway? You couldn't change your clothes at the judo studio?" He kept apologizing. I said, "Just get out of here." I emptied my grass catcher and went back through my garage so I could mow my backyard. I left the big garage door open, knowing I would need to go back out to the alley and empty the grass catcher again. I thought about the creep that I saw in the shed, but I knew there was a judo studio on 18th and Broadway, so I believed him. I'm sorry, I'm shaking. I mowed my backyard, and once again, I dumped the catcher in the shed in the alley. The guy was gone. I pushed my mower back into my garage, leaving the big door to the alleyway open. Inside the garage was a small niche where I stored my lawnmower. As I shoved it into the storage spot, I heard a loud voice yell, "Get down on your knees and don't turn around." I turned around to see the guy from the shed standing in my garage, pointing a handgun at my head. I remember looking at his face and smiling, trying to recognize who it was. I was sure that it was one of the WSP troopers that I worked with who was trying to be funny. But it was Mitchell Gaff. He yelled, "I said, don't turn around, you fucking bitch!" And he slammed the gun into the side of my head. I put my hands up and started saying, okay, I'm sorry. Again, he hit me in the head with the gun and yelled, "Turn around, you fucking bitch." I turned my back to him and he shoved me into the niche where I had put my lawnmower. He then shoved me towards the concrete wall and yelled, "Get down on your knees." I kept saying, okay, I'm sorry. I got down on my knees with my back to him. I kept talking. I said, "Let's go in the house. We can go in the bedroom." He again hit me with the gun, then slammed my head into the concrete wall and said, "Oh, you'd like that, wouldn't you? So your husband can help you?" I said, "No, I'm not married. I live alone. We can use the bed." He kept kneeing me in the middle of my back while hitting me in the head with the gun. I kept apologizing to him. He kept yelling, "Shut the fuck up," while knocking my head into the concrete wall. The reason I wanted him to go into my bedroom was because I slept with a .38 Smith & Wesson handgun under my pillow, and I knew I would blow his brains out. Out of the corner of my eyes, I saw him put a duffel bag on the floor beside me to my right. It was open, and I saw that it had clothing in it. He started removing stuff from the bag, including a huge pink dildo. He placed the items on the floor next to my right side. I kept sobbing and telling him that I was sorry and I wouldn't report the attack. Then I told him that my boyfriend was a Washington State trooper and was coming to my house any minute. Every time I said something, he slammed my head into the concrete wall. He continued to unpack the duffel bag. Out of the corner of my eye, I saw him put the gun down on my left side. He then yelled at me to put my hands behind my back. He grabbed my left wrist, and I knew he was going to cuff me. I figured that with the gun out of his hand, I had to take a chance and fight before he handcuffed me. He was squatting down behind me, trying to tie my wrist. I threw my weight against him towards the wall and away from the gun. It caught him off guard, and he fell against the wall to my right. I jumped to my feet and tried to get past him, but he blocked me by standing in front of me, face to face. He was screaming, "Now you are gonna die, you fucking bitch." I thought he would grab the gun, but he kept bending over, reaching for the inside of his left boot. I was hitting him and screaming for help. He kept me from getting past him with his left arm while he continued to reach towards his left boot. Suddenly, he pulled a hunting knife from his boot and yelled, "Now you're gonna die, bitch." I immediately put my hands up and kept saying, okay, I'm sorry." He slashed me across my palm. I knew he was going to kill me, so I shoved him and somehow got past him and escaped into the main part of the garage. I then ran out into the alley and onto 19th Street, screaming for help and bleeding, thinking that he was chasing me. I ran west towards Rucker. A man driving north on Rucker stopped to help me. He put me in his car to take me to the hospital. I was crying and bleeding and told him no, we needed to look for the guy. He drove me through the neighborhood, looking for the suspect. He saw people watering their lawn on Rucker and told them to call Everett Police. He was so kind to me, and I regret never knowing his name or thanking him. An Everett PD officer arrived, and I got in the patrol car with him. He relayed the suspect's description to other patrol officers in the area. He wanted to transport me to the hospital, but I wanted to look for Gaff. We drove through the neighborhood with no luck. I asked him to call the Washington State Patrol's Everett office and let my sergeant know what had happened to me. We continued to drive through North Everett looking for the suspect. Within a few minutes, the officer received a radio call from another Everett PD officer. He wanted us to contact him down at the Everett waterfront. He said he was with a person on foot near the railroad tracks at the bottom of the bluff at Grand Avenue Park. He said the clothing description of the suspect that I had given the dispatcher didn't match, but he wanted me to take a look at the person to be sure. We drove down to the waterfront where we saw the Everett officer and 2 WSP troopers standing with a male individual. We stopped the car but didn't get out. The officer asked me, "Well, what do you think?" I was mad. I said, "It's not him. He doesn't match the description I gave. I said he was wearing blue jeans and a dark top, not light colored clothes." The officer radioed that the detained male was not the suspect and that he could be released. We started to drive away when it occurred to me that I had been flicking something out from under my fingernails. I knew instantly that it was skin. I remembered scratching Gaff when I was fighting to get past him. I told the officer to back up and let me go up and stand next to the detained individual. I remembered that I had consciously taken an inventory of the man who confronted me so that I could provide a description of him. Cop mentality. I could tell approximately how tall he was when we stood face to face in my garage. I knew what he was wearing. I knew what his voice sounded like. I walked up to where the Everett PD officer was standing. The 2 uniformed WSP officers were there also. I stood next to the detained male, trying to measure his height compared to mine. Same height, same hair, same body build, but totally different clothing when I remembered. But everything else was the same. I looked at him and said, "Say something to me." He wouldn't talk. He wouldn't look at me. He stared straight ahead. I knew it was him, but I wanted to hear his voice. Again, I said, "Say something to me." He continued to ignore me. The Everett officer said, "Say something to her." Gaff turned to look at me and said, "What the fuck do you want me to say?" I knew it was him. I lunged at him. My WSP sergeant and WSP boyfriend both lunged at him. The Everett PD officers had to hold the 3 of us back. I was crying as I confirmed that he was the one who attacked me. The Everett officer asked me if I was sure. I said I was positive.
I said that he had totally changed his clothing, but I knew his voice, his face, his hair, his height from standing face to face with him in my garage. I then remembered flicking my fingernails in the patrol car. I told the other officer to check the left side of his neck. There were fresh fingernail marks running down his neck.
If I may, Your Honor, defense is just going to renew our objection to this victim impact evidence, as the focus should be on Ms. Vesey and Ms. Weaver and the impact on their families. Thank you, Your Honor.
Thank you. Your objection is noted for the record, and we'll allow the speaker right now wrap up things pretty quickly, but we will, the comments will be part of the record, but you can finish your remarks, please.
Okay, I will skip to the bottom. Although he didn't rape me, he affected my life forever. I am always uneasy and overly cautious when I'm working in my yard. When I'm home alone, I never have the TV on unless I am actively watching it. I no longer play music or the radio in my house. I must be able to hear every little noise. I have warned friends and family to always make a noise if they are approaching me in the yard or anywhere else. I often think of Judy, Karen, Angela, and Myra, and their families and friends. Your Honor, my nightmare occurred 47 years ago, but it seems like yesterday. I sit at my computer today writing a letter to you with tears rolling down my face. I hate that Mitchell Gaff still has the ability to affect me this way. But I'm also angry at our judicial system. The judge who sentenced Gaff for attacking me in '79 was a mistake. When he pronounced the sentence, I couldn't believe it. 30 days in the Snohomish County Jail on work release and 5 years probation. While on probation, Gaff broke into the homes of Judy Weaver, Susan Vesey, and Angela and Myra. I remember at the rape trial for Myra and Angela, the judge said that he was very sorry for the lenient sentence he had handed Gaff. I hope your sentence keeps him in prison until his death, Your Honor. Thank you.
And thank you for addressing the court today. And I want to just say this for purposes of the record, given the objection that was made to the last speaker speaking. The facts, as a lot of the facts that the speaker addressed in her remarks to the court are already contained in information that this court has, some of which are contained in the sexual deviancy history that the defendant has provided to the court as part of the psychological assessment that the court should review in terms of determining the risk of recidivism. So the information is before the court. Part of that is also included in the affidavit of probable cause, which the defense at the time of the plea says the court could consider as part of sentencing. So those are remarks that are before the court, some maybe not as detailed as some of the other facts here, but the court has some of this information ready before the court from both sides. I just want to put that on the record in light of the comments and the objection. Anything further from the state?
That is all the victim impact statements, Your Honor. Besides what has already been submitted to Your Honor for review prior to today's hearing.
All right, then thank you, Ms. O'Brien, for addressing the court today. Nothing further from the state, I take it then?
No, Judge, thank you.
All right, anything from the defense?
Your Honor, just Mr. Price's statement to the court.
All right. You may proceed.
Your Honor, if it pleases the court, I come to you before to take full accountability for my actions, behaviors, and crimes related to the 1980 and 1984 rapes and murders of Miss V, Bissy, and Miss Weaver, for which I have been charged and have pled guilty. I am without excuse or defense for my crimes, except to say that drugs and alcohol were both contributing factors which I chose to use in excess. These fueled and magnified my pain, anger, fears, and distortions about women and sex. Upon entering the Washington State Penitentiary at Walla Walla in 1985 with a 21.5-year sentence, I realized what a broken, damaged, angry, and violent young man I was. Confused and pain-filled, I hurt others in the mistaken belief that it would somehow lessen my pain. It did not. Looking back over my life, I saw that I had become increasingly out of control in every area of my life and relationship with others. Drugs like LSD and mushrooms drove me further and further from all sense of reality. Drugs like cocaine, amphetamines, and PCP made me more and more violent. I had become a runaway train through the lives of everyone I came in contact with, violent, selfish, and aggressive, with family, friends, and strangers. I cared for nothing except what I wanted and what I thought I deserved. I fought in bars, at parties, and on the streets with little or to no provocation. I committed assaults, burglaries, thefts, robberies, rapes, and the murders I've been charged with. I believed back then that anything I was strong enough to take and keep was mine. Those were my distortions. Those were my thoughts, actions, and mindset on drugs and alcohol, and I had no one to blame but myself. But now I'd like to impress upon the court what I've spent the past over 40 years doing in response to my realization of just what a damaged human being I was. I'm not presenting this because I believe that I deserve compassion, mercy, understanding, or forgiveness. I know I do not. Today I have over 40 years in AA with sobriety. I have not had a drink of alcohol or taken a hard drug since my arrest in 1984. I joined AA upon my arrival at Washington State Penitentiary. I've attended weekly meetings for over 40 years. I've had many sponsors. I've read all the literature I could get my hands on, and I have not used any hard drugs during those years. I have smoked, however, some marijuana after it became legal, and I was off DOC supervision, but nothing else. Also, during the past 40 years, in my search for sobriety, sanity, and spirituality, I have spent over 30 years in Buddhist study and Zen meditation, spending about 10 years studying under a Buddhist Roshi teacher before becoming ordained in the tradition of Lin Chi at the end of 2018. While incarcerated, I spent 15 years in Native American circles and sweat lodges, finding it to be one of the most profound spiritual experiences of my life. It also prepared me for my studies and meditation. For many years, I've also been a member of the Seventh-day Adventist Church, deepening my prayer life. I am grateful for all and every path that has led me to become the man who stands before you today. As we say in AA, we strive for progress, not perfection. And I commit to your honor in this court and to all who listen that I will strive for progress as a better human being, no matter where I spend the rest of my life, and I expect that to be in prison. The last thing I would like to say was that I was told during my 25 years in sex offender treatment that saying I'm sorry means less than nothing to victims and their families. Nothing I could ever say or do could make up for what I have done and taken from others. But I am sorry, not because I was caught or the consequences. No one did anything to deserve me coming into their lives, and I can only hope that everyone involved can find some resolution or closure through all of this. And I pray that each may find some measure of peace for themselves. Sincerely, Sam Price.
All right, thank you. Anything further from the defense?
No, Your Honor.
First, I would like to thank the families of Susan Vesey and Judith Weaver and their friends, and Mr. Bryan, who's also come to address the court today. To the family of Susan Vesey and Judith Weaver, this court has heard your words and I have read your victim impact statements. There's nothing I do today that will ever replace the loss of your loved ones or get rid of the pain you have suffered and continue to suffer from the murder of your loved ones. The defendant comes before the court today for sentencing following his guilty plea to 2 counts of first-degree murder. In count 1, the defendant pleaded guilty to the first-degree murder of Judy Weaver with a premeditated intent on or about the first day of June through the second day of June 1984. In count 2, the defendant pleaded guilty to the first-degree murder of Susan Vesey with a premeditated intent on or about the 11th day of July through the 12th day of July 1980. Both crimes predate the application of the Washington State Sentencing Reform Act and come under the indeterminate sentencing scheme in effect prior to the SRA. Under the indeterminate sentencing scheme, the defendant faces a sentence of a mandatory statutory minimum of 20 years and a maximum sentence of life. The parties have a disagreed sentence recommendation. The defense is not disputing Mr. Price's criminal history or the real facts of the instant offenses, and in the defendant's statement on plea of guilty, the defendant stipulated to the court considering the affidavit of probable cause filed in this case as part of sentencing. The defendant's history consists of sexually motivated, extremely violent crimes against women. The defendant's sexual history contains some of the most heinous acts of violence that this court has seen. His crimes between 1979 and 1984 have resulted in death, trauma, and grief, and pain for survivors and their families. His crimes created distrust and suspicion amongst family members and friends, some of whom were believed to have been responsible for the murders that occurred in each case. In 1980, a jury convicted the defendant of assault on the second degree and burglary in the second degree, arising from a violent attack of Ms. Brown outside her home in Everett on November 21st, 1979. That attack was random and sexually motivated. Less than 8 months after that attack and less than 2 months before his trial began in that matter, the defendant entered into the Everett home of Susan Vesey and brutally sexually assaulted her and murdered her. The defendant admitted that he was out there that day looking to rape women or burglarize in his statement on plea of guilty. This crime also appears to have been random. On June 1st, on June 1st through the 2nd of 1984, the defendant forced his way into the home of Judith Weaver and proceeded to brutally assault her physically and sexually, and then murdered her and set fire to her apartment in an attempt to cover his crime. A few months later, on August 28th and getting to 29th of 1984, the defendant entered a home in Everett through an unlocked door and proceeded to brutally assault 2 teenage sisters physically and sexually. Defendant pleaded guilty to the crime of first-degree burglary and 2 counts of rape in the first degree arising from the incident involving the teenage sisters. These crimes were committed while the defendant was still on probation for the 1979 assault and burglary conviction. The defendant served prison time under an exceptional sentence of 138 months in 1994 and 2000, 2 separate juries found the defendant to be a sexually violent predator, and he was civilly committed. The defendant participated in sex offender treatment for a prolonged period of time, and in 2006 was released on the lesser restricted alternative. Defendant remained out in the community until his arrest in 2024 for the murder of Judith Weaver. State recommends that the court sentence the defendant to a maximum sentence of 733 months, to a minimum sentence of 733 months and a maximum term of life. The state argues that the sentence is appropriate based on the defendant's criminal history and that the sentence is proportional to what the defendant would face if he was sentenced under the SRA. The state further argues that the defendant has not been rehabilitated. The defense, on the other hand, argues that the court should impose a statutory mandatory minimum sentence of 20 months and a maximum sentence of life in prison. This recommendation is based on the fact that the defendant has spent 33 years in confinement and civil commitment since 1985, has received sex offender treatment, was released to the community on a less restrictive alternative placement in 2006, and unconditionally discharged, I believe it was in 2018. The defense argues that the defendant no longer meets the definition of a sexually violent predator and has been crime-free since his release until he was arrested for the murder, one of the murders at issue in this case. There's also the fact that a psychosexual risk assessment report authored by forensic psychologist Dr. John Lohman determined that the defendant is a very low risk for sexual recidivism. In considering the appropriate sentence here, this court has significant concerns as to the findings that the defendant poses a low risk of recidivism based on the years of concealment of the true extent of his sexual deviancy. Sex offender treatment providers in this court's view did not have an accurate understanding of the true extent of the defendant's sexual deviancy. They were not aware that the defendant's sexual deviancy actually included multiple murders. Consequently, this court does not know whether the defendant would have been released from commitment as a sexually violent predator as the defense argues, if the sexually motivated murders were known to the different providers in this case. But this court also has significant concerns about the defendant's efforts to lie about the extent of his sexual deviancy. This court has reviewed the transcripts of the defendant's conversations with his husband while he was incarcerated. The defendant's recorded communications with his husband, someone who this court assumes is of a very close relationship to the defendant and one that should occupy a place of trust, contains statements in which the defendant minimized his involvement in the murder of Judith Weaver and stated that he was there to assist some other individuals who intended to get into that home to retrieve a product from that house. He referred to some sort of gang, and he was supposed to be the front person, I think, to break into the house. This was in 2024 while he was speaking to his husband, knowing what he had done. This court has reviewed the transcript in which the husband seems to be asking the defendant about the extent of his involvement in the case and saying, perhaps you might get to a time where I can actually ask you these questions and you can speak freely, and I paraphrase here. In that communication in 2024, the defendant lied to him. As recent as February 2026, during another conversation with his husband, the the person who this court also assumes occupies a place of trust and is one of the individuals referred to in the risk assessment report as one of his support factors. The defendant also lied again to his husband, referencing in that conversation that the court has reviewed that the murder of Judith Weaver was committed by some sort of family relative, and the family was aware of who that individual was. Again, furthering this suspicion amongst family members as to who killed Judith Weaver. Suspicion that extended over her live-in boyfriend, suspicion that extended over friends. And this was the same for the case of Susan Vesey, in which her husband was suspected for the murder, and his brother as well, both of whom had gone to their final rest, not ever knowing the answer to the questions. Well, one of them, I think, didn't know the answer to the question as it relates to the defendant's murder of Judith Weaver, but as I recall, Ken Vesey, I believe was his name, passed away before the defendant's plea. So he never really got the answer to the question. These denials and blame of other individuals as recent as February 2026 gives this court concern as the court determines what weight to give to the risk assessment report. While this court recognizes that the defendant over the years prior to his conviction for these crimes may not seek to admit to the crime of this magnitude, this court cannot disregard that in its assessment of whether or not the defendant's information provided to all the providers was credible. And so as I review the risk assessment report, which the defense has also now presented to this court, I noted and highlighted that section where in the clinical interview with the provider in this case, the defendant also lied to Dr. Lohman about the situation involving Judith Weaver, claiming that I think he had been responsible for sort of kicking the door open, I think it was, and started engaging in certain acts based on his deviancy, and then was interrupted by another member of the group that came into the home and pointing to some other person as being responsible. This was the same provider who was assessing his level of risk. So what is the court to do with this information? The report that the court is supposed to rely on in finding a low risk of recidivism, I understand the defense's argument that some of his reports were also corroborated by people who were observing him at the time he was civilly committed. But again, this court notes that the true extent of his deviancy was never really revealed. So what do I do with that information? What does the court do when the court determines that the court cannot find in this case that the defendant has a low risk of recidivism? Because the court does not believe that the information that was based on was, some of that information was an accurate account of the true extent of the defendant's sexual deviancy. The court does recognize the defendant has participated in treatment. But again, the court is also mindful of the purposes of the SRA as reflected in RCW 9.94A.010, which the defense cites to in its brief. state is correct that a court in sentencing a defendant under the indeterminate sentencing scheme prior to the SRA is also directed by RCW 9.95011 subsection 1 to attempt to set the minimum term reasonably consistent with the purposes, standards, and sentencing ranges in the SRA. The purpose of the SRA is to ensure that the punishment for a criminal offense is proportionate to the seriousness of the offense and the offender's criminal history. Another purpose of the SRA is to promote respect for the law by providing punishment which is just, to be commensurate with punishment imposed on others committing similar offenses, to protect the public, to offer the offender an opportunity to improve himself or herself, make frugal use of the state and local government resources, and to reduce the risk of reoffending in the community. With this in mind, and knowing the history in this case, this court cannot find that a minimum sentence of 20 years is consistent with the purposes of the SRA. So what then is the appropriate sentence in this case? The family of Susan Vesey have had to wait 46 years for the answer to the question who murdered Susan Vesey. The family of Judith Weaver has waited 42 years to receive an answer to the same question. Some family members have passed away without getting that answer, without justice. This court believes that consistent with the purposes of the SRA, as previously announced on the record, the appropriate sentence as a minimum is the number of years that the family had to wait. The minimum of 46. This court therefore imposes a sentence of 50 years as a minimum sentence. I believe that would be 600 months and a maximum sentence of life. Based on the fact that the defendant has been incarcerated for as long as he has been, this court will find that the defendant is indigent. Given the lengthy confinement that is coming up, this court finds that he is indigent at this point, and this court will waive all non-mandatory fines and fees. I don't recall if the state asked for restitution in this case. Can you remind me if you did?
We did not. It was not available under the pre-SRA
Under the
statute.
PRSA. So, therefore, the court will approve the no contact order as requested. The defendant will be prohibited from contacting those individuals contained in the no contact order. This court's decision in the appropriate sentence that the court has announced is not driven by the extra comments that were made by one of the individuals who addressed the court today, previously known as Ms. Brown, Jacqueline Brown. The court has considered the aspects of that incident as contained in the affidavit of probable cause and in the history of sexual deviancy that the defendant indicated that the court would consider. The court recognizes, Mr. Gaff, Mr. Price, that you have made efforts at treatment and you have come to a place in your life where you find yourself at peace. Essentially, I do hope that regardless of the sentence imposed in this case, that you continue to spend the rest of your days trying to make amends for what you have done. You may not be out of custody, you may be incarcerated, but in there you have the opportunity through your own lived experiences to share and to help others who may be going down this path. The recommendation that has been requested by your attorneys is not one that the court, under the circumstances, can give. That's the sentence of the court. I will also inform you at this point that even though your conviction has come by way of a plea, you still retain certain limited appellate rights. Should you choose to appeal your conviction in this case, and if you receive the sentence out of the standard range, you must file a notice of appeal within 30 days of today's date, or your right to do so is irrevocably waived. You also have what is known as a collateral attack. which is one way to challenge your conviction and sentence. In this case, you must file such an attack or challenge within 1 year of today's date, or the right to do so is waived. You have now lost your right to use, own, or have in your possession a firearm, and that right remains lost to you. And in federal law, that includes a firearm and ammunition, and that right remains lost to you until and unless restored by a court of competent jurisdiction in the state or at the federal jurisdiction. During any period of confinement now, you've lost your right to vote. Under Washington law, that is returned to you automatically upon release from total confinement with the Department of Corrections. Ms. Wolfenberger, from your perspective, is there anything I should address that I have dealt with?
No, Your Honor, nothing additional.
Thank you. Mr. Matheson, from the state's perspective, is there anything that I should have addressed that I haven't dealt with?
You may have mentioned it, but I missed it. The court has given him credit for time served since his arrest.
Credit for time served will be applied since his arrest on this matter.
And Your Honor, we'll just add that Mr. Price will waive signature at signing of the judgment.
So he was signing at present,
Presence at signing, yes.
Presence at signing, okay, so accepted. Anything left from the state?
No, Judge, thank you.
All right, to the families and friends, I wish you well. Thank you for addressing the court today. Mr. Price, Mr. Gaff, good luck to you. When recess.
All rise.
Troy's grabbing.
Yeah, he's forced to, he feels washed out. He said he spent most of the time out of anesthesia. He kept telling me 3 times, I need more anesthesia. Or he didn't know if he said it out loud, you know.
That makes sense. Reach across it or something. Far in the back.
So appreciate you guys. We appreciate you so much. So much. No. Thanks for turning.
I'll come over there. Well, I'll do it.
So good.
Thank you.
Me too. But
Appreciate that.
I just need something needs to be done.
Sorry.
Oh, yeah.